Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Elizabeth Cronin shares tips for liability-shifting provisions in an event waiver. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. I am the Chief Community Officer at Law Insider, and I'm here with my friend Elizabeth Cronin. Elizabeth, how are you today?
I'm great, thank you.
You know what I don't like to do, Elizabeth? My kids make fun of me because I used to never want to go outside. Now I'll go outside for gardening, but you know what I won't go outside for, this is our pivot, is cycling. I'm not going to do it, and mainly because I'm afraid of the forms that they make me fill out. That's what I'm bringing the people at home today, is this document. I'll show it to the folks at home, is the USA Cycling Assumption of Risk, Release of Liability, Covenant Not to Sue, and Indemnity Agreement. I am a person who has kids, so I have seen 100 of these things. Every time my kids want to go outside, I feel like I'm signing one. Elizabeth, what is this document? When are we going to see it?
These are great documents, and they are such an important tool for anyone offering a sports type recreation. It is so important, especially for a small business, to cover themselves for liability reasons. You will see these, and they really are enforceable. And people don't understand that, but they really are enforceable. So they're a great tool for any business. Of course, they should also have their insurance and also their employees to be properly trained, which will be important, as will come later with the agreement. So the USA Cycling Assumption of the Risk, Release of Liability, and Covenant Not to Sue, and Indemnity Agreement, it's all in bold and it's underlined. And that is important right away because fair notice doctrine might apply. And especially some jurisdictions, they don't like these release of liabilities. So they're going to scrutinize them. So, for example, Texas wants to make sure that people know what they're signing. So that's great. Bold, right on the top, exactly what they want. Then the first paragraph is a consideration. So again, it's a contract. So you want to put out what the consideration is, and the consideration is allowing participation in the event. So that's good. It's right on top. Then the first clause is an assumption of the risk.
Yeah, let's talk about that. So we're going to pivot to the chunks of language that are in this document and just get a sense of all the things that I've signed my kids up for that I never realized. Let's start with the assumption of risk. Underlined, we have, I am aware that cycling and or participation in an event, which is defined separately, involve inherent risks, and going through some simple language about it's everybody else's fault. I fully understand that participating in an event is an extreme test of a person's physical and mental limits, and that's why I don't do it, and may involve the risk of serious injury or death,
Yes.
Economic loss, property damage, etc. And it could be because of the inactions or underlined negligence of others. What do you think about this assumption of risk language?
This is really good because, one, it's alerting that there are inherent risk. And again, that is key language for courts, that you are an inherent risk of a sport. It just is. You can't perform the sport without these type of risks being involved. So it's key that you're alerting that they're inherent risk and you are agreeing to them. So this is an assumption of the risk. Assumption of the risk can also be, you don't even have to have a contract and it can apply. But here, if you're smart, you have your agreement. So you have a contractual agreement for it. What is important is that they use the term negligence and negligence of others. So this is capturing everybody. What I like about this is because this is going to be going over, it looks like public streets, maybe private streets. It's encompassing a lot of things they have no control over. So they're putting weather conditions, streets, that someone's agreeing that they're assuming the risk. But the key is they're assuming the negligence of others. People don't realize that, your instructor can be negligent, and that's an inherent risk. So they've underlined it and they bold the language. So you're agreeing that people are going to be negligent, and that is key. particularly in some jurisdictions, they want that word negligence. I'm in California. They're a little bit more open that you may not have to have that phrase, but it's really better to have it and spell out specifically what it encompasses.
Well, and to your point about the state's interests, I mean, they are very anxious about people doing things like releasing claims, right? So in the second section, we have the release of liability. I hereby forever release, waive, and discharge the USAC, USA Cycling Development Foundation, and the people that they're trying to protect through this document, including from any claims that may arise out of or related to my participation in an event, including claims arising from the ordinary negligence of releases. What do you think about this release of liability? Does it sound effective to you? Are we worried about how states are going to react to that?
I think, again, it hits all the markers. And what's good is it covers volunteers. It covers anyone. Because let's say you're a property owner and it's going over your property, the cycling, you want to be protected. So it's saying, but it's used the word ordinary negligence. And that's interesting. And whoever drafted it was correct. Ordinary negligence is covered. But if you increase and are reckless, that is not going to be covered by your agreement. So they correctly stated only ordinary negligence is going to be covered. What I should bring up now that practitioners should think about is that this normally such agreements to contractually agree to a tort, to waive a tort claim, would be void against public policy. And most states have statutes on that. These become an exception. So in California, for example, it's agreed, these normally are void, but there's no public interest in having someone to oversee sports, to involve themselves in a contractual agreement for sports. This would be unlike something that does have a public policy, such as this type of agreement for a nonprofit hospital. So those it doesn't cover. And it sounds silly, but years ago they used to try that. So when states look at these agreements, they always reference this public policy that normally these agreements would not be enforced. But if they do the fair notice requirements, talk about negligence, they are going to uphold them. So,
all right, well, let's jump to number 3, the covenant not to sue and indemnity agreement. It says, I will not make any claim against releasees for injury, damage, death, etc. Releasees may seek to recover all of their costs, including legal fees. I agree to indemnify, hold harmless, defend releasees from and against any actions, causes of actions, etc. Again, there's this question of we're giving up the ability to make claims. What do you think about 3 and the ability to go sue your rights in court?
Again, I like it. It's bold. It's number 3. It's separate. So, they're numbering everything. It's underlined. I will not make any claims. It's at the end they underline again that the releasee can recover their costs, including legal fees. So it's a great alerting that this is what's going on. And you can kind of see that this is some way, this gives someone a right, that these US cycling assumption of the risk, it gives them a right to go after you. It's actually like a contractual right. It's a little bit different. Where the other is a shield. You cannot sue me for my negligence. This one is more giving me a right to come after you if I am sued. So it's kind of a little bit of a pivot. This doesn't come from me. It's one of the, I think it was Prosser on torts. And it was something to think about. Like, it's a pivot.
And I want to ask, there's an indemnity in here. It says, I agree to indemnify, hold harmless, and defend.
Yes.
What do you think about the indemnification in here? Effective?
I think it's very effective. I think they did a good job. Exactly. And they spell it out: damages, costs, attorney fees, judgment, liens, indebtedness. And again, it could encompass someone's on the bike trail and they run into someone's car or something. You just don't know. And it's good. It's broad. And I think it's a great, I think it spells it out pretty well.
Got it. Side note, I got a call from my son this last weekend. He was running in a Spartan race, and my son has a genetic condition called Ehlers-Danlos syndrome that makes his joints not work very well, and naturally, he twisted an ankle. They called me and asked me. I'm sure at some point he filled out some form that said, I represent that I am in good health and proper physical condition to participate in an event safely. This is Section 4 of the health and medical treatment.
Yes.
It starts with this representation that you're pretty springy, you're pretty spry, you're okay. What is this doing? What is this? Where is this fitting in with the health and medical treatment? It sounds like they're trying to make a baseline of like, we're not accepting your weirdnesses. What do you think of this section?
I think it's good. I think it kind of goes up to the assumption of the risk. I am, voluntarily participating in this. It's just reinforcing, I represent also that I'm in good health. So, you can't come up with the claim, you should have known I couldn't do this. So it forecloses that possibility. And I think it's good. And it's to alert someone to think about it. Should I be doing this? Is this proper for me? So I think it's a good release. It's a good one. And depending on what the practitioner is drafting, some you might even want it more encompassing, but it's at least a minimum that should be put.
Yeah. Well, I want to take you back to kind of the bigger question, which is, to your point about the public interest with this. This is sort of a weird balance to me because you are saying, hey, we like people suing each other. This is how we govern our society. This is how we make sure that people take care of each other, as we have this right to make claims against each other. But to your point, this is riding a bike. So how do you balance that? If you're the person drafting, you want to call attention to the public care that you're sort of taking on without creating new liability. Are you seeing that balanced out well? What kind of counsel would you have on balancing that?
I think they did a good job. And unfortunately, you have to make these like they are detailed. I forgot, I should have mentioned, first thing practitioners should do is to consult any statutes that might be applicable. Arizona has, to protect horse riding, there were so many lawsuits that they enacted legislation saying if you draft them this way and you include this language, these type of agreements will be upheld. I assume maybe certain states, maybe with skiing or something else, might have similar legislation. California, funny enough, is very strong on these type of agreements, maybe because there's so much recreational activity in the state that people would not be able to offer. So I think courts, even if they're reluctant, they will enforce these as long as, so that's where I would lean towards alerting. Because that's the whole. If you can somehow say there was a dark spot, you didn't know what you were signing, but if it's laid out really well, I think it's better to go that way.
Right. Half of it is just smacking people upside the head with bolds and underlines. So it seems well formatted there. I appreciate you bringing this to us, Elizabeth. For people who want to learn more about you, maybe reach out to you, learn more about the practice, what's the best way to connect with you?
I guess my email. I guess my email address. So, and that's KEKECRONIN1@gmail.com.
Great. Well, we'll have a link to contact you over at lawinsider.com/resources, as well as a link to this contract if you want to go check it out. Also, if you want to be a guest on the Contract Teardown Show, just email us. I'm at community@lawinsider.com. We would love to have you. Elizabeth, again, thank you for joining us. We'll see you all next time.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.